evening and good to have you with us on another edition of the Urban Debate. Viewers, it's been over 2 years since India's own Me Too movement exploded. Over 2 years since it became a big movement, especially online, where women from across walks of life and different age groups decided to speak up against their sexual harassers. Now, while a few of them ended up in courts, one became the center of attention because of those involved. One case was that of MJ Akbar, who was then a union minister, and what started was the disclosure and sharing of an experience by Priya Ramani. This journalist not only spoke about what happened to her, but also said that she wanted to do this so that many more who've had worse experiences of sexual harassment by MJ Akbar over the last decades come out and speak up. And that happened. At one point, there were at least a dozen women who found the courage and the inspiration in the likes of Priya Ramani to speak up, to come forward and share their horror and their ordeal. Now, as the outrage grew, as the controversy became bigger and there was pressure on the government, Mr. MJ Akbar decided to sue Priya Ramani for defamation. He said that years of my reputation as a veteran journalist and a senior editor and as a minister has been tarnished and destroyed by Priya Ramani's tweets. So while on one hand you had women, over a dozen women, who were reliving their horrors, but finding the courage to speak up because they thought it was time for a change, and finally there was a platform where they could do that. Mr. MJ Akbar was only thinking and talking about his reputation and how his reputation had been tarnished. And so this became a very crucial case. Why we pick it up today, on the day that Ramani has been acquitted of the defamation charges, why we pick it up today is because I believe this is extremely crucial for many of those who fear shame, for many of those who fear big repercussions, who fear big legal repercussions from powerful men. This is a lesson, this is an inspiration, an encouragement that you too perhaps can speak up. This case is important to understand where the movement goes from here and what it is that the Delhi court said that can be used. Now, I know while one side is extremely euphoric about the fact that the court has ruled in favor of Priya Ramani, and we will actually show you and run the details and text details of what it is that the court said. I understand that while one side is euphoric, the other side also very violently points out that it's odd that we are celebrating a fact that a complainant of sexual harassment ended up becoming an accused in a case and had to defend herself and her comments while facing a suit of defamation. And today what we're doing is only celebrating that part. It's not still justice in terms of what are the repercussions and what is it that MJ Akbar will have to face. He is still a Rajya Sabha MP. He still enjoys many perks and privileges in our society. Can we take it a step forward in this case and other cases? Those are some of the questions I will put across to the panel today. A panel of women who do know how to speak their mind, who have shown the courage to come out and speak up. A panel of legal representatives and experts who will help us understand what this verdict means for the Me Too movement. So let's say good evening to the panelists who are joining us right now on this show. Shuta Paul, author and media entrepreneur, also one of those who's made allegations against MJ Akbar, joins us this evening. Mr. Kailash Vasudev, senior advocate of the Supreme Court, with us this evening. Anu Bhuyan, journalist with India Spend, with us this evening. Mihira Sood, advocate with the Supreme Court, who in the past has shared her own experiences. And Sanjay Hegde, senior advocate with the Supreme Court as well. Thank you to all of you for joining me right now. Shuta, I want to start off with you. 2 years since, a lot of you decided to go public with what had happened and what you hadn't spoken about earlier to this point. Do you see this as a big victory, Shuta Paul?
Absolutely. I think this is a phenomenal victory for all the women, not only in our case, but all the women who have spoken up regarding sexual harassment in India. The 2.5 years, it's Priya who's been facing this head on, a completely baseless, ridiculous criminal defamation case, which has been slapped on her only as a means of silencing women. It's only a means of intimidating women by powerful, influential men. And I'm so glad that today's verdict is a vindication of all that Priya has said, everything that all of us had come forward and said. And the wording of the verdict is very important. I think it makes some extremely important observations. And I think that is a positive for all women. It will go a long way in ensuring women empowerment, encouraging more women to come out and speak up. And also, my hope is that it ensures safer work environments for women. We need more women in the workforce, so let's make it a more safer environment for them to come out and join the workforce.
Well, let me ask you this, when this case was filed, did it give the sense to you that, oh, well, this is what happens, this is why often we don't speak up, this is going to become a big, long legal entanglement where the woman will have to constantly prove her point and prove what she said and herself? Or did it make you feel a little disappointed, or did it make you feel more angry and, make you decide that, yes, you want to go forward and ensure that this time, you fight together?
It angered us for sure. It's one, it's something that was, Priya was sort of targeted in a way which was a message sent to everyone else that, you will be faced with extremely lawyered up opponents if you raise your voice. And that is the same power struggle that perhaps, we definitely faced when we went through those traumatic experiences. And I would like to say that, these are 25, 30 odd women who came up and spoke, varying degrees of sexual harassment from the 90s right till 2010, 2011. It's a complete pattern that came out. And these were women, we didn't know each other. Okay, most of us did not know each other. It's just because we wanted to back the initial couple of women who came out, and we knew that we had to stick together. So when this case came out, obviously, Priya was the one again facing the getting the raw deal, but all of us were completely in support of her. But as I said, hats off to her. She's an inspiration, and Rebecca and her team. The good fight that they fought is a vindication for all of us.
Yeah, I think my favorite moment was to see both of them together and smiling, at everybody who was there at the court today, smiling for the cameras. And that really made my day, and I'm sure for a lot of you as well, to see that sometimes, when you come together to fight the good fight, there is good in the world and something does come out of it. But let's talk about the case itself and what the court said. And Mihira Sood, I want to start off with you. The fact that the court mentioned that they understand that for years women may not be able to speak up for mental trauma reasons or for the fear of social stigma and shame. Does this give impetus to the argument that there cannot be a timeline and a deadline to when you decide to speak up? Will it shut down people who ask you, oh, why didn't you speak then?
See, I think it's very important to understand that these timelines and these deadlines and things like that. Maybe if you are pursuing a criminal trial, these things might matter. Or if you are, seeking, damages in a civil case, these things might matter. But to simply be able to speak out and to speak your truth during a worldwide movement where women are doing this, and to speak your truth on your own social media or your own platform, and to be told that even that has to conform to the timelines of a criminal trial. I think that's a really onerous task, a burden that victims of sexual harassment should not have to bear. And the fact remains that it's a very unprecedented kind of move. Me Too was a very unprecedented kind of movement. And it's not as if the law necessarily envisaged how it was going to deal with it.
Yeah.
When it drew up these timelines. So yes, sometimes you have to sort of roll with the punches. You have to, assess the situation and assess the importance of a moment in time, which Me Too was, and to crack down on that just really shows a complete misprioritization. But having said that, the fact remains that today the bar is so low that we are celebrating the acquittal of a victim rather than the conviction of a perpetrator.
Correct. Correct. Well, yes, the bar is that low, and that's where you have to start off from. But you made a very valid point, and let me take it to the other legal experts before I bring in Anu and Mr. Kailash Vasav, to start off with you. The fact that this was an unprecedented movement, and the way it was taking place in our country and across the world, not too many people were keeping the legal repercussions in mind. So, in the last 2 years and to the judgment today, what could be the lessons learned?
Good evening. Look at this situation in a very different context, where the essential defenses for the rights of women comes from the Supreme Court in 1997 in the Visakha case. Visakha was the first time that international norms were incorporated in our municipal laws for protection of women from harassment at the workplace, Justice Verma's judgment. Subsequent thereto, the movement all over the world began to pick up because of the intimidation and harassment of women. Women have a right, and they will bound to proceed with it, the Weinstein cases. Today, what the court has done is, it has rejected a complaint filed by a person who has been named for sexual harassment by a group of people and one particular lady who was accused by him. Defamation is a right available to you for the purposes of defending your position. The present judgment says this is an honest statement and therefore it is not defamatory. That's the theme of the whole judgment. Refers to the Me Too movement, refers to the rights of ladies, and correctly says that if the lady comes and makes an honest statement, she is not liable for defamation. That is how I understand the judgment from page 87 onwards. So truth is a defense made available to a person who has been charged for defamation. Limb 2. This case arises out of a case for sexual harassment alleged by a lady and a public post made in the social media. There has been no, I'm not aware, I'll stand corrected if there is. I don't think there is any proceedings launched against Mr. Akbar for this particular action so far. A defense has been taken by him by filing the defamation case first. This opens up a totally new flank. The judge's observations of the Me Too movement, by observing that this is an honest defense taken by Ms. Ramani, has now put Mr. Akbar into a bit of a jeopardy. Jeopardy because his claims have been rejected. The defamation has been thrown out. Therefore, defamation rejection virtually gives a free handle to the accused to initiate proceedings on terms and for offenses which they find right. Insofar as the Me Too movement is concerned, it is here, it should stay and should continue. I recall On the social media, there was another case against a very famous artist in the Delhi High Court, where the court said, please disclose a lot of information. The persons who were making the tweets on Twitter and the like did not choose to do so. Eventually, that case against the case filed by the artist, he succeeded. So look at it in two perspectives. Allegations made through social media without disclosing the source, that happened in the artist case. Here is allegations made by a person who claims to have made them and is willing to stand their ground. If you stand your ground and you succeed, which you have chosen to do in this particular defamation matter, leading your own evidences against other witnesses, I think gives a totally new angle to defamatory proceedings, as also the Me Too movement. I'm reasonably sure that the judiciary will protect anyone who comes to it. It has chosen to do so. It laid the foundations in 1997 for the 1997, yes, for the foundations of the Me Too movement in India.
Okay. In fact, picking up from your point, and there are two aspects now that I want to break down this conversation. One is about what this verdict may have as an impact on the actual allegations of sexual harassment, and if there is a way forward there. And the second one being to the entire debate that you have about you can't go public, or you shouldn't be going public with allegations, especially when you may be choosing to not follow it up with a criminal action case. So Sanjay Agre, let's start with the latter. Is there anything in this verdict for that you shouldn't be speaking up publicly about and accusing someone of sexual harassment or assault when you're not going to even be filing a case?
No, there's nothing on that kind. Actually, this judgment helps women make up their mind that even if they speak up, even if the other side comes after you in a criminal defamation, it is most likely that you will be acquitted. And therefore, you need not fear that your allegations will land you in trouble. Now, you asked the other question about whether the sexual harassment charges against Mr. Akbar in the case of Priya Ramani could be prosecuted. There, I'm afraid the answer is not, because the incidents complained of are in 1993 or so, over 25 years ago. At that point of time, you did not have the vast breadth of law which is currently available after the 2013 amendment to the IPC and the Criminal Procedure Code. The events which have come out in the judgment would at best amount to Section 354, outraging the modesty of a woman, would carry a small jail term for which limitation would arise. After a lapse of time, certain offences which carry small sentences cannot be prosecuted. So, the Priya Ramani MJ Akbar transactions of 1993, no prosecution can be launched, in my opinion. Right. But if there are fresh incidents which come to light and of a more recent vintage, and particularly after 2013, maybe those incidents can still be complained of.
But can this verdict, and like Mr. Kailash Vasudev said, this verdict says we go with your truth. We are accepting the truth that you've put out, which is why we don't see it as defamation. Now, if they are accepting what Priya Ramani has said to be the truth, shouldn't that at least be enough grounds for some kind of other action? Should he, I'm just asking, can he continue to be a Rajya Sabha MP if it effectively means that he did do this? Sanjay Agre.
Well, as far as the Rajya Sabha is concerned, it is possible for the Rajya Sabha to probably expel him if he does not resign on his own. It can also possibly become the subject of a privilege motion if some other member were to move it. The members of Houses of Parliament have been expelled. You remember that the Rajya Sabha itself expelled certain members who took cash for asking questions. So it is possible for the Rajya Sabha to take action, but I think the best course for the BJP itself would be to secure his resignation.
Okay, all right. Anu, thanks for patiently waiting and hearing everybody out. Let me start off by asking you, for you, what was the biggest takeaway from what the court had to say today?
Hi, Tanvi. I was in court today. I had been covering this case in the past. Today, I pulled out a lot of newspaper clippings I'd kept from 2018. So this is October 16th, 2018, where it said MJ Akbar files a defamation case against woman number 1. So Priya Ramani at that time in 2018 was called woman number 1. Today, I think everybody knows her name. Everybody knows MJ Akbar's name. So I'm looking forward to tomorrow's paper. As for the court hearing today, I think a sentence that a lot of us women are sharing on WhatsApp and on social media, and I think men should probably be forwarding this to each other as well, is that the judgment said today that a woman has the right to put her grievance at any platform of her choice, even after decades. Essentially, I think this judge is a pro-Me Too judge, because he said that I am free to post on social media if I want to about my sexual harassment, because it says any platform of my choice. And it says that I can talk about this even after decades, which means I don't have to go to a police station tomorrow and file a complaint. I don't even have to use the police route, because I can choose any platform of my choice to talk about sexual harassment that has happened to me. So this is really the biggest takeaway for me, for women, but I think men should especially be forwarding this to each other on WhatsApp.
Fair enough. I completely agree with you, which is why I did not even want to go ahead with an all-women panel today. I know it's very common thing that we see, but I wanted a panel where we have representatives of at least two genders speaking about it, because if any larger change has to come in, it has to be with everybody together. So let's pick up on some of these points further. And one of those aspects is the fear of repercussion. And what many of you have already, mentioned, the fact that you can go and take any platform which is available to you, take the platform of social media, especially in the absence of a proper grievance redressal system available. Mr. Kailash Vasudev, can this be seen in a broader light, or will it be specific to a case from a pre-Vishakha guideline time?
The law is very specific. It prescribes the offense, it defines the offense. It prescribes the period within which the initiation of proceedings must take place. The Me Too movement is an allegation of sexual harassment, and as Sanjay rightly said, the 2013 amendments have their own fallouts. But one is doubtful if the period of decades can come into this matter. You cannot possibly raise issues which have lied buried over time. You cannot wake up one fine day, excepting possibly in the American system, where the law of limitation doesn't apply. In our country, we are regulated by time factors, by regulatory systems in which we can initiate proceedings. Under the under the Civil Procedure Code, you have a limitation period of 3 years. Under the Criminal Procedure Code, you have a prescribed period, offenses with a certain amount of punishment and beyond. If it is less than a year, your period of limitation is also 1 year. So it depends. Hence, the judge's observation that he can go to court after decades, to my mind, is not sustainable. What is sustainable is the dismissal of the complaint, saying that the lady's position is vindicated by truth, because that's a defamatory suit. The second question which you posed was, what is the remedy available to a lady who has been through this sad experience? Please go and file a suit for recovery, file a criminal claim, but merely reporting it on social media opens up flanks for the lady to be prosecuted if she does not want to go to court. She has to vindicate her position. She has to prove a charge. Otherwise, the restrictions of law come into play.
What are these restrictions of law? One remedy could have been a defamation case, which is what MJ Akbar chose in this specific instance. What else could happen?
Look, you can file a case for being physically touched. You can file a case for being intimidated. You can file a case for being threatened. So there are various available avenues under the Indian Penal Code. So there's a lot of protections available to a person who has been through this. But please remember, you must be able to make these things with clarity and have evidence to support you.
Okay.
The courts don't take a situation when an allegation is made, it does not lead to a conviction. An allegation has to be proved with cogent evidence because you're dealing with the reputation of a person.
Yes. Okay. Mihira, do you want to add to that before I go to Sanjay Hegde?
I'm sorry.
I just I had a disagreement with the interpretation of the law as it stands today after this judgment, because while I do agree with Mr. Vasudev that there will be complications if you choose after many years to file a civil case or a criminal complaint against a perpetrator, I think the judgment makes it fairly clear that non-legal options, for example, speaking out on social media or using a platform to speak your truth, as long as it is a non-legal option that you are seeking, is fairly, I think, uncomplicatedly clear in this judgment that can happen even after many years. So I think to that extent, I do disagree with Mr. Vasudev's reading. I don't think it does or should open you up to any kind of legal liability.
Yeah. Yeah, Sanjay Hegde, because this was the point that I also found interesting. If you choose to only, speak your truth on a public platform and not follow it up with criminal action, then what?
No, you would still be liable for defamation. Then, if you simply put out an allegation on social media and the person came after you with a defamation complaint or a defamation suit, the difference being in a defamation criminal complaint, you can go to jail. In a defamation suit, you could be asked to pay compensation. You would still be vulnerable to those complaints. This judgment cannot be seen as granting immunity for anything said on social media. What happened in this particular case was that Priya Ramani took a particular defense which was available to her in criminal law, that this was true and this publication was made for the public good, so that other people in similar circumstances could be saved from the consequences of such predatory action by Mr. Akbar. That is a very specific technical defense in criminal law. If you go through the judgment, which I did scan through, the judgment holds that what was said was possibly defamatory, but nevertheless it was protected by an exception to the criminal section where such publication is made for the public good. Now, if your viewers, any of your viewers were to say that 30 years ago this thing happened, and then that person were to file a defamation, I'm afraid that the person concerned would have to go through the same process.
Okay.
Of the same court process that Priya Ramani went through. However, just one thing. If you make an allegation, you are in a position to prove it, and such declaration is made for the public good, it is possible that this judgment can come to your aid.
Yes, because let me just read the part. The court just says the court accepts the contention of the accused, which is Priya Ramani in this case, and the possibility of defense of the accused that she disclosed the truth regarding the incident of sexual harassment against her at the Oberoi Hotel in 1993 on the basis of the testimony given by her, and also the testimony given by another witness, which is Nilofer in this case. So that's what they've based it on. Mihira, you wanted to make a clarification.
Yeah, I think the last part of what Mr. Hegde said is broadly, touched upon what I wanted to say, which is that, when you can always be open to, vulnerable to a proceeding being initiated against you. That is someone's right. But I think that the likelihood of that proceeding succeeding against you in such circumstances is greatly diminished by this judgment.
Okay, fair enough. I want to go to the second aspect that specifically got my attention in this judgment. And Shuta Paul, I'm bringing this to you first. The court also accepted the contention of Priya Ramani that the complainant, which is MJ Akbar, is not a man of stellar reputation.
That's right.
And which was a big thing, because the entire case by MJ Akbar was about, oh, my reputation, oh, all that I have done, brick by brick that I have built, and you just destroyed it with one tweet. So this obviously is a very key highlight from what was said in the court today.
Absolutely. The fact that the judgment says, the verdict says that reputation is not greater than dignity. I mean, what can be a more powerful statement than this? And the fact that, the verdict goes on to say that people of high status or of, strong status can still be sexual harassers, what they do in their private life. I mean, there's so much of detail, which, our legal experts, of course, will be able to deliberate more on. But definitely, it shows that when you have 15, 20, 30 women coming across, coming out and talking about this, there was this whole sense of a power struggle, obviously, between your boss and your subordinate. And then years later, you're speaking against somebody who is in the government, as a minister. So there was tremendous pressure on a lot of us who came out and supported. Obviously, again, Priya was the one who was facing the brickbats from the very outset, from the time that this case was filed on her. But the fact that the verdict here has so clearly said that dignity matters so much more than reputation, and the judge has said that he accepts the fact that the person in question is not of stellar reputation. I think that is a vindication. Again, it's a word that I've been using all evening. Vindication is really what we feel right now. We feel vindicated. All the things that we've said, everything that Priya has gone through, the enormous pressure on her of traveling back and forth between Bangalore and Delhi 2.5 years with a little kid. I mean, seriously, I think that's the word, vindication.
In fact, let's take it a step forward and say, from where do we go from here on? Anu, whether it's the aspect of, well, an argument about your stellar reputation will not really hold any value, or whether it's an argument about the lack of a redressal system, which I know there are guidelines, but there are still problems that exist in our system. Where does this verdict take the movement from here on?
I think the movement was designed to intervene in a very specific gap that exists in law, which I mean, the lawyers on this program are talking about it in technical terms, which is this idea of a statute of limitations, which is that after a certain amount of time, a certain period of time, even though a crime might have happened to you, it's not something that the legal system can deal with. And the Me Too movement was designed to especially intervene in this gap. Because for the law, my case of sexual harassment may not be valid because it has happened too long ago. But this judgment says clearly that women cannot then be left with no avenue to speak about it. And which is why I think the judge has said that talking about it on any platform of your choice is your right. The judgment says the woman has the right to talk about her sexual harassment on any platform of her choice, whether or not the law can take that into account. Now, where the future of this really is, I mean, if lawyers and policymakers and parliamentarians want to establish a law that allows me to come with my decades-old grievance and be heard in law, that will be great. But if that doesn't happen, the future really is that I can still talk about it. And this judgment says that I'm allowed to talk about it. Now, as the lawyers have said, yes, there's always a risk of defamation. But as someone who stood in that courtroom for many, many hearings over 2019 and 2018 on Zoom, it is clear that Priya Ramani was able to show evidence, and which is why she was able to turn this defamation case over. So you are always at the risk of defamation, but as long as you have evidence on your side, you will be able to turn that in your favor. So the future really is, I would say, women can actually speak about things that have happened to them and then be ready for whatever comes next. But, if Priya Ramani could win it, perhaps another woman could also win it. I also just want to make one clarification, if there's a minute, Tanvi, to what Mr. Vastev had said right in the beginning. He declined to name the artist that he was talking about, but he was referring to the artist Subodh Gupta, who had filed a 5 crore defamation case against an anonymous Instagram handle. And Mr. Vastev said that he won the case. However, in this case, Subodh Gupta withdrew his case, and the anonymous Instagram handle that had posted about him was not disclosed and made public either. So it seems from that judgment as well as this judgment, courts are in some ways protecting the right of a woman to come forward in a social media platform, even anonymously, to talk about people who sexually harass them. So it's, I mean, men or perhaps lawyers or perhaps male lawyers will have one way to interpret this. But as a woman and as a non-lawyer, I see these two judgments where the Instagram handle was not made public and the court allowed that Instagram handle to be private. And in this case, where a woman was allowed to talk about it on her social media platform, I see these two judgments as the way forward for women.
Okay, Mr. Kailash Vasudev, do you want to come in?
Yes. You see, as far as the artist case is concerned, Instagram did not want to disclose the name of the person concerned.
Yeah.
And Google said, I will not put this on record. I will take away this. I will not publish anything about this. Therefore, the case was withdrawn. It never happened that the disclosures were made. The artist withdrew it because he was told that this would not be carried in on the web by certain sites, which he had named. And they were taken off. So please don't say things. The disclosures were not made. The disclosures were not made, and a redacted statement was made in that case. Please see the order.
I have seen the order. That's not much of a victory. He didn't get a rupee out of the 5 crores that
I'm not speaking of a victory. I'm saying a totally different thing in law. Either you make a full disclosure and get ready to fight the battle, or if you don't, then you will have a difficult time. That was my stand. It still is. If you want to make an allegation, please make sure that you follow the Visakha judgment, the 2013 amendments to the law, because everybody has a right to be defended. You have a right to make an allegation, but you must be able to prove it. That's my stand.
No, so I think everybody really agrees that when it comes to the legal battle, it's not going to be easy ever. And I know for a lot of us who've seen it from a distance, it just feels like a moment to rejoice. But it's Priya Ramani who had to go through it and fight it at every stage. But what I want to understand, and especially from Anu and then Mihira as well, is what happens to the movement in the sense of, do we really see it making a change, Anu? Apart from the one aspect is to have to be able to say it out loud and share it with people. But beyond that, have we seen any significant changes that have happened because of these within our working systems or the people who've been accused of these allegations?
When it comes to whether we've seen change, I also have the newspaper copy from October 2018 where the government said that they're putting together this panel that will look into this.
Yeah.
So, I mean, governments and policymakers have great responsibility to do it, but this panel was quite a damn squib. We really haven't heard anything about it since 2018. So it seems like governments will take their own sweet time to do something, or perhaps in this case, nothing. And so then putting the burden of change on, someone like me or someone like Priya Ramani or any of us women who are at the receiving end of sexual harassment is probably unfair. So as long as courts and politicians and policymakers don't respond with adequate redressal, women will have nothing left to do other than exactly what this judge has said today, which is to take to any platform to talk about our grievances.
Yeah, and I think the change also has to come from our setups, from our, especially our work setups. Whether you are working in the judicial setup, whether you're working in the political setup, or in the parliament, or political party, or in the corporate environment, that change has to come. And honestly, I believe that hasn't begun in this country, and which is why it is so important to have these conversations and continue pushing. We don't, most of our political parties still don't have a grievance redressal system. I am pretty sure that there are many cases, some of which we've addressed in the past, that the problem still exists even within the legal fraternity. Meera, you wanted to make a point earlier. Sorry, I couldn't come to you then.
Yeah, a couple of things. One is, MJ Akbar's case is somewhat unique in that you don't have too many cases where somebody is such a serial offender and they have so many dozens of women coming forward making the same kind of allegation against him, which certainly helped Priya Ramani's case. But if you're going to expect the same standard, in every kind of case, and if you're talking about cases that happened decades ago and, the entire emphasis on you must have evidence. I mean, the evidence is literally going to be people you spoke to about it, people who are willing to stand up and give testimony on your behalf. But the fact is, sexual harassment is not something that, necessarily happens in front of other people. It's not always something that, I mean, especially years ago, but even today, it's not necessarily something that, somebody will send you a WhatsApp or an SMS over. It's, it's that you're going to have that kind of forensic evidence. So when we talk about evidence, we need to be very careful that we are not placing an undue burden on the standard that women have to meet in order for their claims to be proven. And in that context, I think the law needs to step in and recognize that while certainly a man cannot be convicted in the absence of an evidence, a preponderance of evidence against him, but there may be many cases where a woman is not able to bring a legal case forward because of a lack of evidence, but that doesn't mean that the case is not true and doesn't have merits. And to that extent, I think the law needs to come in and protect people speaking out in the form of Me Too or other such, on their own platforms. And I think two things that I would like to see the law do in the future. One is we should not have criminal defamation altogether as an offense. Criminal defamation should not exist. It's on the statute books. It's been misused far, far, far more than it has ever been used correctly, which is because there is no real need for a criminal defamation law. And the second thing is that I think specific exceptions, even in civil defamation, should be carved out to protect women who are speaking their truth, but for various reasons, including the nature of sexual harassment itself, are not always able to bring it to a court of law.
Yeah. Okay, so I am completely out of time, but I do want to take one point forward from here and maybe to Mr. Sanjay Hegde on the question of law. And because sexual harassment, by its nature is so difficult to prove in terms of evidence, can we look at tweaking the law, or do we just hope that your case is strong enough and you get a judge who is more open and understanding towards these kind of Me Too issues?
Well, if you tweak it too far, you can equally well have abuse on the other side. It can't be that, somebody just says that 30 years ago, this man did this, and therefore I'm putting it out on social media, and all of you do what you want with that. You are in effect calling for vigilante mobs possibly, or all kinds of consequences which can't be foreseen. So there has to, if you make an allegation, there would have to be some methodology where it has to be proved. You may tweak the standard of proof a bit here and there, but you cannot totally abandon it. Otherwise, it would become totally one-sided. It would leave a lot of people entirely vulnerable to allegations without any reference to time, place, circumstance. Mm-hmm. There is one sentence out here which my fellow panelists have been relying on, but I think that is being read out of context. However, forget all these legal quibbling. Today was a good day. Today was a day when somebody took on one of the most powerful people in the land and won. An attempt to shut her down has failed. Let us savor the moment and let people take their own lessons from it.
I am completely out of time, although I must say that I think Mihira and Anu were just warming up to this conversation with Mr. Kailash and Sanjay Hegde on the other side. But maybe another day on another show. Thank you so much for joining me on this. Yeah.
Please have a show one day on false allegations and the bogey of false allegations that is constantly raised whenever there is a woman-friendly law that is being proposed. I would really love to be part of that panel.
Absolutely. Done. Thank you so much. Mihira, point noted. And we do have some of these conversations quite often when such cases emerge. And I think a lot more of those are required because this false allegation is a counter to what has been happening on a very, very large scale for decades and centuries together is really an argument that I think is too soon to make. But we'll get to that another day. For today, let's just say this, that one lady started this off by talking about a very, very powerful man 2 years ago. and how he had sexually harassed her on the first day when she went for a job interview to him in 1993, when she was a fresher and he was already a well-established editor. After she said so, many more stepped up and shared similar experiences and worse when it came to MJ Akbar. Now, there isn't a legal case, criminal action against him, because all of these allegations are from a really long time ago. But this is a victory, however small it may seem to many people. And this must give you heart that if you have truth on your side, then all you need to do is find some courage and a support system like Priya Ramani managed to go and fight this battle. You must call out your predator then. Thank you so much for joining us.